Yes, we file an application.
Notice is not served. What is the notice is not served on the respondent.
Ask her.
Notice is not served on the respondents. Then what is the urgency? What is the urgency then?
Oh, this wedding season you intend to get married, right? That's the urgency.
Huh? The appellant. Interim order is against the respondent.
Against it. Interim order is in your favor. Then
Why should you be bothered if it is not served? An order is passed, it is binding on you. Merely for the reason if it is not served, it does not mean that the order is not in force. We can't explain you. Yes, next.
Mr. Natraj, tell him what he should required to do. Tell him Mr. what to do.
It's already in the hearing list.
What if probably grievances is not being listed? Yes.
Already in the hearing list earlier.
We do not issue mention memos for final hearing. Hey, Mr. Ramesh, please help us. We do not issue mention memo for final hearing. Otherwise, the requirement of filing an application for urgent hearing will be discussed with. Yes.
Number 2, for pronouncement of judgment.
Appeal is dismissed.
One for
2 weeks preliminary.
Lord, I'll serve the copies, my lord, on the proposed respondent. I'll serve, my lord, I compliance. Two days time.
2 weeks time preliminary.
Grateful.
2 weeks preliminary. 2 weeks preliminary. 2 weeks preliminary. Return PF. 2 weeks preliminary. 8/19 third time. 2 weeks preliminary. No, which case? Item 7. Short question, absence of, in the absence of this thing, substitution of LRs of disease respondent number 2, not taking steps for R8, R18, R19 third time, and non-compliance on IA for stay. All this is 2019, 3 years. 2 weeks time peremptory. 2 weeks peremptory. Learned counsel, despite order being passed, learned counsel for the appellant insisted that the application for a stay should be considered. The matter is not listed for consideration of IA 1 of 21 for a stay. On the other hand, it has been listed for non-compliance of office objections on IA 1 of 2021, 1 of 21. Therefore, the prayer made by learned counsel for the appellant cannot be exceeded to let the office objections be complied with within 2 weeks, failing which appeal shall stand dismissed without reference to bench. Acceptance of court notice, service, served, respondent. You are for the respondent. So and so, what's your name? Anusha Nandish. So and so has entered appearance on behalf of the respondent. The service of notice on respondent is held to be sufficient, and then write so and so appears on behalf of respondent. Record is there. Huh? Let the appeal be listed for final hearing in due course.
Number 9.
Appeal for the appellant, my lords. In this
2
case,
weeks preemptory.
I may be permitted to take through the permanent address in India, your lordship, and also through email, your lordships.
Tell her 2 weeks preemptory.
Madam, 2 weeks granted, madam. Peremptory.
Permitted to, I have filed an application, your lordships, in that regard also. So I may be permitted to take a service.
What application file?
No, there was an order, if it is not, a office objection is complied, will be subjected to dismissal, and there.
Which is file? Why this?
Madam.
Don't come to court now. I don't really know.
On 22/2/2021, my lords.
2 weeks time preemptory. That's it. We don't know, it's not listed.
Number 10. Srinivas Sankhya.
Furnishing of PF on filing. 2 weeks. Preemptory.
11. CDR Balgar.
It's preemptory.
Shastri.
Memo for retirement. First file memo of retirement. Memo of retirement has been filed on behalf of M. Ashwath Narayan. The aforesaid memo is accepted. Office is directed to delete name of Mr. So and so from us.
Okay.
Preemptory.
My lord, I am for the appellant in this case, my lord. My lord, I may be permitted to serve the copy through her one more connected matter. I can be permitted to serve the copy to the council, my lord.
No,
Because in one more connected matter,
no. This is a matrimonial dispute.
Which is the connected
yes,
matter?
my lord, there is one more RPFC 3/2021 wherein respondent has been represented by council. So I may be permitted to serve the copy because my lord, she has changed the address.
You find out the, if you can find out who is appearing, you can find out the address also. Change address.
My lord, the question in matter is, my lord,
No.
saying it
Something, Mr. If we direct, I mean, this is unfortunate that we are required to explain what are the consequences of your unreasonable demands. Supposing if she files an application for review that I had never instructed that person to appear in this appeal, and without any authority he has appeared, and she files an application for recall, what would be the consequence? And your your insistence on serving a copy instead of paying process fee, that means you are not interested in prosecuting the appeal. That's what I mean. Don't do it. It will be dismissed. What is there? 2 weeks preemptory, we have said. Don't do it. Don't pay process fee.
No, I will pay, my lord. I have already taken, but this time I'll take one more. I'll issue process.
But 40, okay, Sugaraja.
Publication taken. Publication. Memo filed. What is the matter? Let's see. What is it? What is the matter about? A purchaser. Notice has been issued. Okay. What happened? Commissioner has allowed the application. Notice is accepted, then let 2 weeks time is granted to take steps for substitution of alarm. PC. More dated so and 6. Then it council correspondent 6 leave of this court to withdraw. Memo dated 27/9/21. Accordingly, same is dismissed as before.
But I appeal for the appellants in this matter. But
Very.
appellant intends to withdraw it, my lord, with a signed memo, my lord. I'll place it on record. 2 weeks time, my lord, without first steps.
Weeks time.
Please,
2 weeks
please.
time.
Appellant intends to withdraw, my lord. So,
You withdraw it. What intents means what?
and in the sense, my lord, I do not have, my lord, a memo signed by the party. So therefore, my lord, I'll place.
We are granting you 2 weeks time peremptory.
Very.
Number 16, Sri Panchamardi.
Then it counsel for the appellant submits that has been taken for the go of opposite submission office to verify and proceed.
Number 17, State Manufacturing.
Weeks.
18,
He is not in a hurry. 2 weeks time. He's not in a hurry. 2 weeks time. So there's no interim order, we hope. Huh? Weeks time to comply with the interim order. Weeks time to comply with office order. What? No, there are several lakes, not Subramanyapura. So let us begin with a water body, which is a lake. Huh? What is it? There are 3 lakes, right? Original records. Bring it. There are record. We will go through this. There are 3 records. Want time? Why? Just now. When will you go through? Day after? Huh? Tuesday. So ready? Yes. Learned additional. Not filing. We will take up and decide what is there. Why should you worry? Let them not file. Oh. Hanging bridge. This name of hanging bridge is frightening, right? Huh? Huh? What construction? We will take it up on Thursday, Mr. Thursday. Thursday. Huh? What is just now? IA 2 of 22. We will take up this application also, apart from this issue. Record. Thursday. You file objections. Hanging bridge also. Find out. Hanging bridge also. Will maintain it later on. Huh? Yes, Mr. Yes. Rate counter. Yeah, all right. Yes, yes. Learn it. We'll take it up on Thursday. There's no point in this thing, right? Deciding one IA this thing. Appearing for IA, but don't appear for IA. Appear for your client. Don't appear for IA. Yes. It's being. What do you want? I mean, your interlocutory application should be decided today and then it should be taken up on like that. What is? That's what it is like, however we please. Because this thing, it's not the way, madam. And this is not a moot court competition. Understand? This is high court. And you don't tell the judge that however he likes. Huh? Don't come if you don't know. We are telling you repeatedly that if you don't know how to address the court, don't come. No, don't come. You must, first of all, you must dispel this impression that this is a moot court going on, where you can say anything. This is not a moot court competition and you are before the high court. If you don't know, first of all, you don't know for whom you are appearing. Then you are telling the court that whatever you may please. Unfortunate, madam, who engages you, and probably the client who has engaged you should see your performance, that he should see that you don't even know how to address the high court and what to say. We are not in an informal conversation with each other. So you are saying that whatever you may like. At this point of time, we are judges occupying this chair and we are under an obligation to respect the chair which we occupy as individuals also, right? We can also commit contempt of this court if we don't behave properly. Please don't tell us. Don't know, should not appear. Send somebody who is more experienced. We are not here to contest the election of the Bar Association so that we need not go for votes of junior counsel by making them happy. We are not here. We are here to maintain the dignity of the court. If you don't understand, please do not appear. Got it? you should find out whosoever is your senior, whatever worth he is. You should find out how to address the court. Do we tell the court that whatever you like? We ask him. Ask Mr. Nanjun Reddy. He will guide you. Ask him outside the court whether we should tell the court like this, whatever you have told us. I think enough of it for the present. Learned additional government advocate submits that he has received objections to IA 2 of 22. 2 of 2022 just now. He prays for short accommodation to enable him to go through the objections filed on behalf of the petitioners. Let the matter be listed for consideration of IA number 2 of 22 as well as IA number 2 of 2022 in WP number 29107 bar 2019 on 17 November 2020.
Okay, reader.
I appear for the appellant, my lord. My lord, I request, my lord, that the appeal was dismissed for default. I was suffering from COVID, my lord. I could not appear on that day, my lord.
And duly supported. Order dated 3rd March. MFA is 225.
My lord, one more on merits, my lord. My lord, on merits, sir.
Delay of 114 days in filing the applications control. Once so is recalled. IA 0. MF.
Yes.
My lord,
But
My
you
lord-
have to take steps to be.
my lord, one submission, my lord. On merits, my lord, the appellant, his husband, he is no more, my lord. The appeal does not survive for consideration. It is a matrimonial matter.
The appellant submits that on account of death of the appellant, the appeal no longer survives for consideration. The aforesaid statement is taken on record. Accordingly, appeal is on the proceeding. Accordingly, the appeal is disposed of. Accordingly.
Number 20. Number 10. Okay.
This has been issued. It's on IAS, on all pending IAS. To propose errors of disease respond number 3. 3 and 5. 3 and 5.
Number 21. Here party. Feedback.
IA number 3/19 shall be considered at the time of hearing of the appeal. What impleading? Already busy. Huh? Number 2. Whether other side has filed objections to this IA. So who is appellant number 2? Impleading applicant. You have filed this application. Pleading you have filed. Asking.
Impleading applicant is not a party to the suit. And why, how? You have already impleaded her and thereafter filed an appeal. And subsequently, you have made an application. He is shown as an appellant here. How without even be the application being allowed, you have made her as a party here?
Heard on IA 4 of 2019, an application seeking impleadment. The proposed applicant was not a party in the proceeding before the trial court, full stop. Even without seeking leave of this court, the appellant number 1 on his own has impleaded. Appellant number impleading applicant as appellant number 2, full stop. The full stop in view of the fact, taking into account the fact that that proposed applicant was not a party in the proceeding before the trial court, comma, we are not inclined to allow the application. Accordingly, same is rejected. Applicant is directed to amend the cost cycle within 1 week.
24, Srimati Ananya, वही समझ Mahe.
Further orders, condonation. After hearing, delay condoned. Yes. What state? You are married. Oh. In practice. Not in. Yes. Not like this. What is this? New practice. New practice, just like handover. Huh? Appeal is admitted for the record. Huh? Find out. If he or she, who are you? She is married and having 2 children. You should better be happy now. Yes. Huh? Yes. We don't know. You can't take everybody by surprise like this. Huh. 23.
Here,
Taking into account the fact that the appeal is pending. Huh? Allowed?
Yeah, 2 of 21 was allowed.
Has been allowed. But this is 2 of 22.
In hearing application.
In view of order dated 15/12/2021, allowing the application for early hearing, IA 2 of 2022 is also allowed. Let the appeal be listed for final hearing on 6th December 2020.
24.
For appellant, my lords, in this case. Three times notice was ordered, my lord. 3 times it was not served. We made application for
IA 1
substance.
of 2022, letter notice be published. Let a notice be issued to respondent for his appearance before this court on 20th of January.
Obliged.
So which January? 2nd week of January now. 16 January for in so and so. For his appearance before this court on 16 January 2022, notice be published in so and so, whatever. What is Rajavan?
Please.
What edition? Bangalore edition. Accordingly, line below IA is allowed.
Please. It's interim order to be extended.
Order, if any, shall continue.
Much.
Come ready. Devi.
What are the terms settlement? This appeal arises out of a judgment dated. Judgment dated 17th of December 2019, passed by the family court by which marriage performed between the parties, by which what marriage has been dissolved. By which the marriage performed between the parties has been dissolved on the ground of cruelty. Paragraph. With the pendency of this appeal, the parties have a right at a settlement. The terms and conditions of the settlement read as under. Like para 4 up to 8, no? Para 8. 8, right? Para 8. In view of compromise arrived at between the parties, the judgment and decree passed by the family court is modified in terms of the compromise arrived at between the parties. The appeal is accordingly disposed of. Oh, get their signatures, madam. Sheet. They have parties along with their counsel present. In the beginning, you write. Parties along with. Yes.
26, which is in a picket, permitted to get, the
What non-compliance on IA4? What is it? Nothing survives. That senior can't change either the rule or the fact that you have studied for 7 years. You can't change it, right? What instruction will he? We will mark his presence only. Who is your senior and where is he? The head counsel for the appellate prays for adjournment on the ground that the arguing counsel is not well listed. After by 4 weeks, she will be all right. 4 weeks. 2 weeks, she will be all right. Let it be. Why should you seek another adjournment? We don't want that you should become expert in seeking adjournment. So let it be after 4 weeks. List after. List in the month of January 23. By that time, I think she will be hale and hearty. Okay. And please don't come. If the roster remains with us, don't come. We remember, we have a sharp memory. We will remember that you had sought an adjournment, so don't come.
Number 27. CV. And number 30.
I am for the respondent number 2 in this matter, my lordship.
27.
27, my lordship. The IA number 2.
Rehabilitation.
The IA number 2 filed by the petitioner seeking direction has become infectious, my lordship. They are sought for direction for admission for the year, academic year 2021-22. So now that academic year is over.
Is it correct? IA is what? IA seeking direction to or when? Your statement is sufficient. Learned counsel for the petitioner seeks leave of the court to withdraw the petition. The same is dismissed as withdrawn.
Number 28.
Huh? Password. Huh? Hold on, delay of 391 days in. This is right, record the rule. Delay of 391 days in filing the appeal is condoned. IE is allowed, the appeal is accepted for hearing. And record. Record there, Mr. Matra. Record. Yes. Not there. Not there. This is directed to record. How do you know interim order? You are needing a password, right? How do you know there is an interim order? Why should you not even tell us what is the delay and why it should be condoned? What is this, Mr. Condonation of delay? You are seeking a password. All friendship outside the court. All there's no. It's not a place to this thing. We have condoned the delay, madam. This is admitted. What to do if we start really, I mean, on the averments in 98% cases, you will be required to file. We take a liberal view. What to do? We are sure that he must not have written what is the how much is the delay, when did he come to know, and all that. But what to do? That's why. And he is please. Why not? It's a matrimonial dispute. Fine. So, interim order, if any shall continue. You don't raise this plea. He's seeking password. He doesn't know anything about the case. And you are telling that reason has not been, what will he argue that? He doesn't know anything.
Admission.
Excited today.
It's only with regard to payment of alimony. I think ಮದುವೆ ಆಗಿದೆ ಅವರಿಗೆ 30 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ 30 ಲಕ್ಷ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ yes already paid 30 lakhs your that amount has been deposited in the name of the wife and children yes yes now it is only with regard to the payment of balance amount. You said you don't want property, you wanted only money. Therefore, we'll ask them how much money they will give you. You had made a submission that you don't want money, property. That is why you wanted money only. We'll ask them how much they'll pay. No. Another 40 lakhs you are ready to give. Another 40 lakhs. 30 plus 40, it would be 70 total. What is your salary? 3 lakh.
Per month. Per month.
How many children? What is What are the other properties which you are holding?
Properties, in Hyderabad. And another one is one property.
Why don't you take a property? What are your properties?
And Bangalore,
What is that? Commercial, residential, residential, Delhi. You are not interested in any of the property. Kadapa district. He is from Kadapa. Can be done. He was not paying any maintenance.
they have filed the. Well, it was participated there.
Pay another 70 lakhs, Mr. What instruction? It is listed only for that purpose. Every time, what instructions? Only for
You
that
have a
purpose.
daughter also. You have a daughter also.
Addition to the salary or getting rental income also.
No manner. I don't get.
not in her name. That property is not in his name, he says. If you have got anything to show that it is in his name, then you will use. Otherwise, we have to go by his statement. What has the family court done? Yes, mister. You are also married now. Therefore, you getting an income of 3 lakhs per month. And deducted means it's only investment, nothing else. It will not go to them, it will come back to you only.
Another 40 lakh.
The 40 lakh. But given the year 2020 only, you had assured that you will be giving that property. That property has remained with you, and you also had assured that 48 lakhs should be given. That also has remained with you.
And then we give property.
That you can give. If your parents are giving, let them give. But so far as your
They were only one property in my name was.
whatever you want to give over and above this 70 lakhs, you are welcome to give them.
Take back the.
Therefore, you better you pay that and get it finally settled. Otherwise, you will be in problem. You have now taken a second marriage also.
As an order, what's that?
No, not necessary. You have already filed your assets and liability statement. You have gone through that. You have got means. It's not that you don't have means. You have got sufficient means. You should have a willingness to pay to your wife and children also. You can both file a joint memo. We'll give you 1 or 2 days. Otherwise, we'll pass out. Not next Monday, Wednesday or Thursday. When? Thursday.
When it counsel for the parties jointly pray for adjournment, to enable them to file a joint memo just on 17th November.
Okay. We take it up. Okay.
So, when will you produce? That additional government advocate prays for adjournment in order to enable him to produce the record based on 17th November.
Everyone, Narendra D. Gowda.
Appeal is admitted hearing record.
22. Raghunath Yadav.
Admitted for hearing record.
33. Rajeshwara PM. Lakshmikant.
Learned counsel for the parties again pray for adjournment to enable them to report settlement list on 24th November.
34. Nayak clear? Yes, Nayak.
Kindly pass over the matter, Your Lordship.
Huh?
Kindly pass over the matter, Your Lordship.
Password.
Yes, Your Lord. I request for a pass over, Your Lordship.
Madam, your senior is already there in court.
We thought that you are opposing him, so that's why.
I was not aware. I could not see him, Your Lordship. That's why I made
Oh,
it.
Mr. Naik, you should stand in a place so that your colleague can see you. Yes. All right. All right. Yes, please. So before 1/12/2005, you have withdrawn. When did they? Yes, yes. So when did they accept?
Taking the settlement duty is acceptable.
So
Sense of due or some particular.
twentieth September 2000.
Why you not getting free for no income factor managing that? The power to.
But why did you accept the dues, whatever were payable to you?
There is some. Why it is free for managing that?
You tender a resignation. What is that? Why should he give reasons?
Effective date is what? Before that, only you not accept. Any director accepted it. Because not for the intended date. 4 reasons are made. Administrative order. There were not expenses as committed. Because the given the reason. I never stopped for acceptance of IBR immediately. special reasons and all. Yeah, given a history case, you not by the court authority is not accepted even before the FIR. The order election, no events are given. And there is a power not to accept the resignation. Earlier, the reason why. And it's like, before the case, not a shipment to not accept.
So, but why did you accept the retirement, whatever dues, and then January 2006, after 4 months, you were challenged?
Back from this back, already back. Okay, Maratha, immediately Maratha entered like January. Everything that comes to enter. First entered in the first, before the lease, then Maratha arranged. Then the thing is worse. These are a better. So you are not getting. Accident was not. Then the second. But the data started to back. Can be expected even there.
Rule 4. Rule 4.
That's not that the rule is also produced. So it's another. Very clear. So what is what page
Everything.
so the maximum quality that desires to retire voluntarily shall be the very voluntary. But rules governing what then as you apply to decide to tell at least tell and at least. They are not they go to rule 4. A notice of less than 3 months may be accepted by the managing director in deciding case. But deciding case cannot be owned in that connection. Why not it is a deciding case to accept even before the intended date of community.
That's it.
Yes.
Thank you.
The 35, 30. Selected every 582 for immediately. I put correct the copy of the application. The objection, any application, what if you did it? The application as well as the
For that, probably wants time. What? Yes.
says, "If allowed to file by the period." So where the work is application. The government creates the original grant and producing certain documents in work before the government. And they take place creating. Saying the new breed of citizens are the shamelessly report also in order to that is written for things to be still of that. So that's just your program justice to bring it back. It's not entirely related. What are the original document can be explained. Saying that printed after years. Based on the documents submitted by the entity that is held in plenary.
All right, you file objections, we'll take it up when you want.
Sorry.
Page 20. Page 20. All right. When will you? Why?
So the value of the report
Next week? What date? Huh? 23rd? Learned counsel for the appellant. 35. Learned counsel for the appellant prays for a short accommodation to enable him to file objections to IA 1 of 2022. And below, learned additional government advocate shall produce the original record pertaining to proceeding the copy of which has been filed as annexure R15 within bracket 2 by the impleading applicant. List on.
Some person responds to it.
Let's see the record, then we will come. Yes, list on 23rd of November 2020. Order if any, then continue. You are not the you are not the new creed, right? Yes. Yes. Yes, 23rd November. This intra-court appeal. Wait, Mr. This intra-court appeal has been filed against an order dated 17th of November 2020, passed by learned single judge, by which a petition preferred by the respondent has been allowed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the respondent was employed as a clerk in Bangalore Rural and Ramnagar District General District Central Cooperative Bank Limited. The appellant, on account of ailment in respect of spinal cord, submitted resignation, submitted an application seeking voluntary retirement on 18/8/2005. In the aforesaid application, the petitioner, the appellant stated that he seeks to voluntarily retire from the service on account of the surgery of his spinal cord with effect from 1/12/2005. However, the managing director of the bank, by an order dated 20th/9/2005, accepted the resignation of the appellant with effect from 1st of September 2005. Full stop. The appellant thereafter accepted the dues which were admissible to him on 30th/12/2005 without any protest or demur, and thereafter raised a dispute under section 70 within bracket 2 within bracket D of the Karnataka Cooperative Societies Act 1959 on the ground in the month of January 2016 on the ground that the resignation could not have been accepted before 1st of December 2005. Paragraph. The appellate tribunal by an order dated 26/7/2014. Paragraph. Delete. The joint registrar decided the dispute against the appellant. The appellant thereupon filed an appeal before the Karnataka Appellate Tribunal. The tribunal, by an order dated 26/7/2014, allowed the appeal and set aside allowed the appeal. Full stop. The said order of Karnataka Appellate Tribunal was challenged by the respondent in a writ petition. The learned single judge, by an order dated 17 November 2020, has allowed the writ petition. In the aforesaid factual background, this appeal has been filed. Paragraph. The writ counsel for the appellant submitted that since the appellant had tendered the resignation, appellant had sought voluntary retirement with effect from 1st of September 2005. 1st of December 2005, the same could not have been accepted by the managing director at an earlier point of time. That is with effect from 1/9/2005. Paragraph. We have considered the submission made by learned counsel for the applicant and have perused the record. Full stop. Admittedly, under Rule 4 of the rules governing the voluntary retirement, the managing director has power to accept the notice even before 3 months. Full stop. Full stop. Rule 4 of the rules reads as under quote. In the instant case, exercising powers under Rule 4 of the rules, the managing director had accepted the prayer for voluntary retirement made by the appellant, and thereafter the dues were paid to the appellant. The appellant, without any demur or any protest, accepted the dues payable to him on 30/12/2005, and thereafter, by way of an afterthought, in January 2016, raised a dispute. February 2016 raised a dispute under the February 2006, not 16, right? February 2006 raised a dispute under the provisions of Karnataka Cooperative Societies Act. The learned single judge, therefore, has rightly set aside the order passed by the Karnataka Appellate Tribunal. Full stop. For the aforementioned reasons, we do not find any merit in this appeal. The same fails and is hereby.
Number 36, C.A. Madhusudan Rao, government advocate.
When was the application filed for resumption? 7.
5 years. Partition of the government, you have purchased.
So has he obtained permission? But that's what you were required to find out, right? That whether or not he has obtained the permission. So that order won't be there in the records of the assistant commissioner, right? The permission is granted by the government. It won't be there. So what have you taken the permission when? Have you taken the permission?
Government.
No, but that is disputed. Madam, produce the record. When? Why 2 weeks? Oh, Mr. Lakshmi Narayan is telling everyone 2 weeks, right? No, he told him also 2 weeks. So, yes. Not so good.
Make a statement on annexure J.
Yes, madam. All right.
Annexure J. Make a statement on annexure J. That's all.
Yes, week's time. When? Thursday. 25th. Yes, Mr. learned additional government advocate shall ascertain and make a statement whether the document dated 29/12/1997 annexed as Annexure J along with the writ appeal is a genuine document. List on 25th you said, 25th November 20.
37, Sumantil Bharadwaj, CT Network.
Admitted hearing record.
38, CPA, Vastavenga.
Admitted for hearing, right? Which one? List for analogous hearing along with MFA number. File an application for urgent hearing. Next.
Number 39, Saturaj TA.
Admitted for hearing record. Is list for analogous hearing along with MFA number.
Party.
Admitted for hearing this record. Nobody's name appears. Pay process fee.
41, Mr. Devier, Ramesh.
Right. What is it, Mr. Ramesh? Ah. 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 We'll admit it. Why? Appeal is admitted for hearing. Oh, sorry, WP. Petition is admitted for hearing. For analogous hearing along with WP number. Tomorrow.
43, take Mari Patil.
How this has come up again? Date given. This you didn't send. Yes, Mr. Ramesh, what's his case? Two-way. What is the category? Talwara. What happened? Allotted the seat in dental. This is when? This is undergraduate course. Yeah. 2910. Subsequently, this has been notified as a scheduled trial after she took admission. Huh? Where do we get it that she was allotted a seat on 2810 in dental?
No, you said she was admitted to dental course. What is the document?
So this is 2910, Mr. Ramesh, not 28. 2910. She is admitted on
28.
2810. Where is that? So subsequent to her admission, this has been notified as scheduled trial. So it can't be reopened. That's it. So what is it? Tell us what is it. That's fine. Fine. Nobody is saying that she doesn't belong. That's what he told.
March 2020. 2 years ago. 20th March, they've already put me as
No.
scheduled trial.
Sir, were you allotted a seat in dental course?
No, I have signed it. I have to.
It says, congratulations. It says, congratulations.
My reputation page. I have started because I'm not selecting that. I have not.
When have you surrendered? When? Date.
8 months, 8/11/2020. I have signed. I have not selected.
No.
Please.
So what? Therefore, you should be given the benefit of scheduled tribe.
20th March 2020. Formally, government remove my name under the same from category. Although I can see only a formal remove it from category 1. That's all. That notification is issued belatedly by the government. I have despite me, I have already having a certificate of SC already been issued by the state government and I have not missing.
Also, Mr. Raman. No, how, I mean, whether she can be permitted as a scheduled tribe. So they are saying 20th March 2020, central government has done it. No, Mr. Yes. Fine. So what happens? So fine. So you should file. When will you file? They should file objection. Fine.
Yes. He has not permitted to participate.
See, you are scheduled tribe, Mr. Not scheduled class. Fine. But what was the caste you filled in your this thing? That they have permitted you to appear. This notification has come subsequent.
Certificate caste. 8/10/2021, I have already issued caste certificate. He has committed a mistake of not permitting, saying no, government was not making drawn. He has mistake, not the government mistake. But already held, I already held that.
Oh,
Under which category you had applied?
then you think
Why?
Yeah.
You are having a certificate.
Yeah.
you produce Mr. the documents, we will take him to task. We will take him to task. We are initially at the sympathy, but I mean the council is trying to be smart. We will take him to task. We had the sympathy, but usual back to his old tactics. We thought he must have improved, but not improved. Fine, fine. We are asking them to. You are saying that you are a scheduled tribe candidate. You have not been permitted to participate in the counseling. He will tell you under which. He will tell us under which category you had applied. Right? Yes. Fine. You have applied under category 1, Mr. It's all. Don't make incorrect. We really have allergy to incorrect factual statements. No, nothing. This is category. This is what he's telling, Mr. What are you trying to tell us? He told us that you have applied under category 1. You are saying that I had already been issued the caste certificate in 21. If nothing. We are asking them to respond to your petition. Nothing. No urgency. No urgency. You will file, Mr. by tomorrow. Yeah. All right. No. If you want to rely us on documents like this, fine. Then don't say that it has not been supplied to me and this has been dismissed. Go ahead. We wanted him to share documents with you on which he is replacing Reliance. You don't want that. Fine. Let nothing. Fine. So you have. That's all right. You have applied under ST category. What is it? I mean, facts are facts. Either you have applied under category 1 or not applied. Mr. Ramesh will pass an order. You need not file reply. He wants without this thing reply.
So then category. It is scheduled for the application itself that is mentioned as category 1. If I put Talavara as my community as a category, because all of them are defined towards the application, it will not show only towards category in the application. So I don't think it is all fix. If I mention my community,
that's what he's saying. If you haven't understood, we can't help it. That's what he said, that you have applied as category 1 candidate. You have been permitted to participate as category 1 candidate. You have been allotted a seat. You have given it up subsequently. Thereafter, after the seat was allotted to you in dental, the state government has issued a notification on 29/10/2022. That notification is prospective in nature, does not inure to your benefit. This is the argument. Now you argue not prevented, whatever, who prevented, whatever. You are asking them to justify their action, but you want a decision right away. We will give you. Fine, go ahead.
To apply for the SC category comes from annexure G, which is a central government notification holding my community having been put under the constitutional amendment order and including my name alerts by an order dated 20th March 2020 under the central government notification, where under MP 38, Nayaka was substituted with Nayaka and Nayakada, including Parivara and Talavara. My community has already by an order 20th March 2020. But subsequently, government issued a notification on 28/5/2020 and Annexure G1. Then the government permits all the Tahsildars to issue caste certificates.
It's not 28/5/20, it's 28/5/2022. 20. Page.
5/2020 government, in light of the taking note of the central government's notification, issued this notification. Government of India, by notification, constitutional amendment 23/2020 with respect to the scheduled tribe list in Karnataka and CH-2. An act further to amend the constitution scheduled tribes order 19 by the list of in entry 38 for the word Nayakada, the words brackets Nayakada, including Parivara and Talavara shall be substituted in entry 50 for the backward words. Sindhi in Uttar Karnataka bracket word Belagavi, Dharwad, and Western Karnataka. Accordingly, the caste certificates may be issued as per the rules by the government. So they should not be taken by the people. Government has issued me a certificate under SC as an SC category. That is Annexure H, page 28. Annexure H, page 28 was the old certificate issued on 8/10/2021 that I belong to the community like Talavara and belong to the SC category. The scheduled tribe Nayakada Talavara, first paragraph. 8/10/2021. But Annexure J is a notification issued on 29/10/2022. They take note of the fact that they have already issued the notification directly.
That category.
It is all India.
This is actually scheduled. Scheduled tribe only applied under, not permitted to apply as scheduled. That's the case.
He has already appeared.
Or
For the NEET also he has appeared.
let us understand his case. We have understood, but his perspective at least.
Since the government had already, put the Talavara under the ST category, and the government also, state government also had issued directions to issue certificates as ST category. They had not put the name of Talavara. It's not OBC category. It was only a formal state government to remove it, despite the right that is already been approved. It's formal. At page 33, the background of that been ordered to remove Talavara, Caste, and Parivara class in serial number 88 and 88 in the category 1 of the government order dated 30/22/2002 of the backward class conservation. So this was only a formality that had to be done by the government. This time was already having petition had already been issued with the SC category certificate. Our notification for saying that I belong to the SC category. Because I have already notes that I belong to the SC category. These are your funds. It's not what it's like. Being issued related. They did not cover the part of the SC category.
Yes. Yes.
Actually, the beginning of the application that I have done.
What about annexure A?
Finding in my part.
What is your caste shown category shown there? Category?
Malord, the OBC entry to the central list. Malord, this does not give a ranking of another category. It just says my application. Even if I participated as a general category student here, I can still gain reservation under the state category. This does not confirm any right. Although a student has mentioned it as OBC there. Because as on that day, the student also in their head, they think because government is not permitting them to participate as SC.
You should write a OBC.
They have.
So one mistake you commit, was some mistake they commit. So that's it. Square accounts settled. We don't know. We don't know. You would have mentioned. The question is what capacity have you appeared? Fine. So you can write anything. You should have written general merit. Why did you write OBC? Huh? Huh? Why did you write OBC?
But that does not that the only the application notes here under notes at page 15. I am not color. If I were to select as Kalavara, it does not show as SC category. It only shows as category 1. At page number 15, the application, these are pre-filled notes clauses. I have to just select those options. I cannot type one of these options. Once I select my Kalavara, it does not permit me to select SC. I cannot select it as SC because I was forced to show it as category 1. Despite as on the day of filing this application, I already have the SC certificate. Last certificate I had already processed on 8/10/2021.
When was the counseling held, Mr. Ramesh? Council. No, when it was that was held?
8/10.
Oh, so when? 8/11 first round, she has participated, right? As category 1. Oh, obviously. Yeah. Which page? 15. Ah. Caste.
But there is somebody did not mention. 592 last number, 9592. Yet last number is 596.
Yes. Wisdom always dawns upon later. Yes.
But since they did not permit, I cannot mention any other. But here, if I mention some other number and then some other category, I want verification of my documents and be able to be my verification of documents has to be in accordance with whatever is written here. That is the reason why I want that number. So,
That's it. Thank you. Other case is same. We hope it's better.
44. Etiquette malpractice.
What is it?
The government knows. Actually, GM allows they have notified an ordinance on 23/10/20.
Yes, Mr. Lakshmi Narayan. That's the prayer.
This ordinance only works.
So you tell us tomorrow, right? What is there tomorrow? We need additional government advocate place for short accommodation to enable him to seek instructions and to make a statement as to when the notification in pursuance of the ordinance issued by the state government, ordinance issued by the state government shall be issued. List tomorrow. Yeah. Yeah. Yes, right now. Item number 43, mark everybody's presence. This writ petition has been filed by the petitioner seeking a writ of mandamus, declaring the mandamus directing the respondents to permit the petitioner to appear in online counseling process of UG medical stroke dental Ayush 2020-22 under the scheduled tribe category and to select the MBBS stroke BDS seats by permitting the petitioner to select the seat under the scheduled tribe category. Paragraph. Facts giving rise to, please sit down, no need to stand. Facts giving rise to filing of this writ petition briefly stated are that the petitioner had appeared in the NEET examination, National Eligibility Test Examination in the year 2020-22 by declaring her category as OBC-NCL within bracket central list, full stop. On the basis of the marks obtained by the petitioner in NEET examination, the petitioner participated in the counseling for undergraduate medical stroke, dental stroke, Ayush in the year 2020-22. Full stop. The petitioner in the counseling process, disclosed her category as category 1. As category 1 candidate. Full stop. She was allotted a seat on 28/10/2022 in dental course as category 1 candidate. Paragraph. Thereafter, it appears that the state government had issued a notification on 29/10/2022 by which Talwara caste was notified as scheduled caste. Scheduled tribe was notified as scheduled tribe. Full stop. The petitioner thereafter has filed this writ petition seeking a direction to the Karnataka Examination Authority to permit her to participate in the counseling as scheduled tribe candidate. Full stop. Paragraph. Learned counsel for the petitioner submitted that the petitioner was petitioner that by an order connection page should be that by constitution within bracket scheduled tribes bracket close order within again bracket amendment act 2020 with effect from 19th with effect from 20th March 2020 comma the constitution scheduled tribes order was amended and the caste of the petitioner namely Talwara was included in the as scheduled tribe. Full stop. It is further submitted that in pursuance of the aforesaid constitutional order, comma petitioner a caste certificate was issued to the petitioner on 8/10/2021 by which 8/10/21 in which it was mentioned that petitioner belongs to scheduled tribe. It is further submitted that belatedly the state government issued a notification on 29/10/2022 by notifying the caste of the petitioner as scheduled tribe. It is further submitted that the petitioner was prevented from to participate in the counseling as a scheduled tribe candidate. And therefore, a direction we issued to the Karnataka Examination Authority to permit the petitioner to participate in the counseling as scheduled tribe category candidate. On the other hand, learned counsel correspondents have opposed the prayer, aforesaid prayer, and has pointed out that the petitioner had participated in the counseling as category 1 candidate and was allotted a seat. However, the aforesaid contention has been taken up by the petitioner by way of an afterthought. It is also contended that in any case, the notification dated 29/10/2022 operates prospectively and would not inure to the benefit of the petitioner. Paragraph. We have considered the submission made on both sides and have perused the record. From the perusal of the application submitted by the petitioner to participate in the counseling, it is evident that she has described her category, her caste as category 1 and has category 1. Full stop. In the aforesaid application, there is no reference to the caste certificate issued to the petitioner dated 8/10/2021, by which the petitioner has been 8/10/2021, which shows that the caste of the petitioner is scheduled tribe. The petitioner has annexed the certificate, a certificate as belonging to category 1 candidate. Full stop. On the basis of information disclosed by the petitioner, she was treated as category 1 candidate and was permitted to participate in the counseling and was allotted a seat in BDS course. Full stop. After the petitioner was allotted a seat in BDS course, subsequently by a notification dated 29/10/2012, the state government has notified Talwara caste as scheduled tribe for the, where is it, Mr. 29/10? Which page?
State government's notification.
29/10.
Where is that?
Page 33. Page 30. So what state government is notification?
After the petitioner was allotted a seat in BDS course, subsequently by notification dated 29.
29/10/2022. The aforesaid notification issued by the state government has a prospective effect and cannot inure to the benefit of the petitioner. Full stop. The petitioner at no point of time has asserted that petitioner did not participate in the NEET as well as in the counseling as a candidate belonging to the scheduled tribe category. Full stop. Therefore, in any case, the notification issued by state government now it will come. Right? State government issued notification issued by state government would not anywhere to the benefit of the petitioner as it is prospective in nature. Now it will come. Like below, for the aforementioned reasons, we do not find any merit in this petition. The same fails and is hereby dismissed.
Evidence? PP Hegde associate. Anand?
What, Mr. Registry can record evidence. No. I think so. Yes. Yes. Why? Huh? What is this, Mr.? So shall we issue? He will remain present, non-bailable warrant, he will remain present. Then what he is praying for adjournment. What to do? Evidence has to be recorded in contempt, right? You are from your client is from Bangalore only. Oh. Traveling expense. $50,000. 2,000 rupees you deposit. Subject to that, the complainant, the respondent has come, she is attending the proceeding. Then 2,000 rupees merit counsel for the appellant petitioner prays for adjournment. You paid to respondent, right? Respondent is present in person along with the counsel. The petition is pending since 2016 by way of indulgence. Hearing is deferred, subject to payment of rupees 2,000 to learned counsel for respondent, right? Which shall be payable to the respondent on or before next date of hearing, right? Tell us a date, otherwise we will call him here. 7 years, I mean, not still satisfied. Huh? Placed on 21st November 2022. On the aforesaid date, party shall remain present. Huh? Huh? All right. Acha. On the next date, the appellant shall remain present. All right. Appellant shall remain present. Next date.
By direction, 46, the Vijay Kumar, government advocate, please bring it in. And
What survey? Where is that?
Action in accordance with law.
No survey, no direction for survey. So you have to take action, right? Tell people to go to court, obtain stay and report action taken. All of them have obtained stay. Huh? What action taken? You should have taken action for removal, mister. What is this? So it's like telling people go and take stay from the court, huh? Advising them. What? You should have taken action. Learned additional government advocate. No. Praise warrant is granted 2 weeks time to enable him to submit the action taken report, failing which appropriate order shall be passed against Deputy Commissioner, Bangalore Urban. Just on give a date after 2 weeks. Mr. 5th December.
number 47.
Lords, I appear for the respondent BBAB. May I make one submission before my learned friend starts, my lords?
Huh.
My lords, I had to be there before your lordships to assist physically. I've hurt my foot, my lords, and I've been directed. I've been asked by the doctors to take rest for a day. But we have complied with the order, my lords, on 10/10/2022. We filed a memo.
Whenever you tell us, when will you appear? Tell us.
Anytime, my lord, any day, even tomorrow, day after, any day.
Yeah. No, he's praying for time. No? We asked you when, day after or whatever. When first? Day after. Huh? We don't know. We don't know. We are asking you, is it convenient? Otherwise, you will say that I am not available. Mr. Sriniti, learned counsel for PMT, prays for a short accommodation on the ground that he is unwell. List on 16.
Obliged, my lords. My apologies.
Final hearing, number 48. And Chandra.
Yes. You are hearing it. Like I said.
Other methods also there, this also can.
Difficulty. No adjournment. Yes. Go ahead. So these two are not. Not common judgment. What is the matter? Yeah, but what's the issue, right? Huh?
Abscess.
Pencil. Big part. Please take one. You are agreed only so far as it pertains to handing over of possession. Mister, you should be brief. What is there? We have seen it. What is your grievance? It should have been dismissed. Petition should have been dismissed. Okay. So petitioner did not avail the alternative remedy. What alternative remedy? But what was the order? Challenge 12/11/2007. Where is that order? Order which was under challenge, Mr. Ravi Shankar, in the rate petition. 146. What is the alternative remedy available to you against this order, and under which provision? Huh?
That is contempt of the order and then still pass the same. Page number 1. The girl cigarette operated 2005.
Hmm.
1976. The 99 years.
10 to 1976. Okay, what are the dates? We want to understand nutshell. What is the? I don't think there is any. He is prepared to argue it for an hour. We are not prepared to hear it. 99. Date is what? 23/5/1976. Yeah.
Working before the time and area, unspent time and area. Now, the investment for doing the after by the or an investment over 50%. Another 15% by the day of 50% that I said, and constructions were actually the constructions were completed. But the lower costs were inundated because of the waterlogging. That is when the ICSW went back and said, these costs we are not able to. Committers, some portion of the bidding was the request made before the government. The government committed the same on 3799. This is not just page 49. Government permitted the subject of a portion of the bidding. This condition was relaxed on 3999.
9.
999. And final pay. This take a versus to get it. Of the even number and directly to state to the petition not to run the road hotel is here by relax. However, the function and make the petition.
So all right. What happens?
Yes. But without yes. Okay. But the commissioner passed an order on 27/9 without any notice, saying that I'm terminating the lease because there's a violation of the terms of the lease. 27/9/2003. This was challenged in the earlier order of petition, the 24/5/2003, which was by the date of the
All right. So it was the order was quashed and they were given liberty to. It is bound by annexure G and H. What are G and H? All right. Yes, what type?
Clause 7 is Clause 7 is
Where is that notice?
very notice at page 130. That's it, so what is comment at page 159? They say that regarding the sublease, there is a violation, therefore we take action to the matter. It's the inquiry notice.
Yes. Then,
Then enforcement was issued at the first instance, saying that there is an order which is passed in which we are cancelling your lease. The subsequent
where is that order?
Saying the order. Therefore, we have telling the change and we put 146.
146, it was cancelled.
Page number 157. Just starting with the pages, the entire controversy which they want to set up. What if it was the lease deed, decision not sublease or part of decision?
No, but again, this order was passed without hearing you. That's why it was set aside. On that ground, it has been set aside. You have also filed an appeal against order by Learned Single. That
The ground which I can support the so the
So what do you say with regard to this? So this order is quashed and possession is taken by corporation illegally, it shall be handed over. What happened? How did they take possession? When?
Golden age.
Yes.
Give the date.
Fine. All right. So what's your problem, Mr.? You are happy with this order. Now, but for past about 12 years, that order is stayed. This intra-court appeal, there was an interim order passed on 3/12/2012. Yes. Now you are out of position. Of course. And the order is only order has been set aside, demanded. So they will conclude an inquiry within 2 months, Mr. 12 years you have suffered the order. We will clarify that whatever you are entitled to claim damages in accordance with law for the period of which you have been deprived. But and 2 months you tell a date, you appear, and he will conclude an inquiry within 2 months and decide it now. There's nothing. That's why we did not permit him to argue. I mean, we wanted to understand nothing like. Yes, Mr. Chandra. Fine. 2 months. No, but see, government has passed an order without hearing the parties. You,
87%, 12.5%. Contract of the completed contract. Meeting was whether the Compromises Act would be invoked. Script of the meeting is. So, we passed on the copy of the. So, passing WP number 25929 of 2000 is also reported.
no, what he says is that what is your submission, Mr.? Please tell us. Huh? What percentage? So you argue whatever, I mean, that it's not percentage and nobody has invested. We have constructed, you argue whatever. No. So why it has been referred to the government? You tell us. No, because it was earlier, the conditions of the contract were earlier amended by the government. So that's why it has been remitted to the government. And how can you be a judge in your own cause? Right?
The contract, and the contract and obligations are there. Read the contract.
No. So, Mr. But how come if this contract was between you and BPMP, in what capacity the government modified the terms and conditions of the contract? So what is?
Why is it inclusive?
Under which provision, Mr.? Of? Yes, Mr. Section 176. Correct, right? 176. So what is, I mean, we haven't, Mr. understood what's your grievance. It should not have been remitted, petition should have been dismissed. So why? Disposal of which provision, Mr. 170? 74.
Not editor, not exceeding bracket 2 years. These are very perfect things. Beyond 2 years, I think. The difference is that the violation was original service. Earlier round of petition, therefore, I read the orders of the current and page 117. Say that they are the corporation formed by the orders passed to the government is 3799 and 3999. Then if that is so, there was no way that they could have terminated these on the ground evidence. It's the only ground on which they have done this. It's very conspicuous. The order which was under child, first your resolution which years have been passed. Prior to the date on which the earlier order was passed in 2005. So the two aspects which we are seeing that, but nonetheless, they still give a leverage to that. That's my respect. I should have also, but there was no way that the matter could have been remitted back to the situation where the allegation for the termination of the lease was non-existent and was transmitted in the previous law of lease. So a lot of it's there, we have to accept it or
So the issue. So they were seeking to cancel your lease on the ground that there was a sublease. That's why, and that issue having been this thing, and annexure G.
Another ground on which you want to another ground on some piece. So some piece is only the earlier ground.
Okay, that's it. Okay, thank you.
Wherever the deed is created with respect to vacant land, it's a district because the construction of the property. The other thing is that somebody will take a view that the Proceedings Act will not be applicable to every building. The dichotomy of ownership between the land and the building in such cases pertaining to the legal by corporation is typically considered. The reason is they wanted a subsequent order after the order had been 1.6 was passed.
So you should have also challenged the order. Then things would have been different, right?
Right.
Yes. Mr. You didn't tell us. We have been asking what's the dispute. You didn't tell us what to do. We had to study on our own and to come to it. Because you are Mr. Chandra, why are you interested in reading this paragraph 75? But you are interested in reading, right? You should tell us what is the point. That's it. We did not permit you to read. That's correct. So, because there everything has a limit, right? No, that's what we are telling. That's how it should be. That's how it should be. Like, you should help us. That's why you are here. You should be able to see that the case is concluded within 10 minutes. And there's nothing, right? Nothing to hear. If you would have permitted you right now, you have been you would have taken us to Maruti Fun City and we would not have known the facts also. So this happened, this lease deed, that lease deed, and that clause and this clause you would have read. And we would not have known what is the point. That's why we were impatient. Very often our experience is the older the matter, the shorter the point. Well, yes. 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 All right, thank you. No, fine. You are appearing for whom? You are appearing for whom? Original lesson. What pains us is that there was a stay operating. You did not make an attempt to get the stay vacated. No, what effort did you make to get the stay vacated, Mr.? Knocking. No, knocking at the door. We had to say no further adjournment. That's why Mr. Chandra is here. And that's why it is being heard. You see the order sheet. See the order sheet. Last date we told. We don't. Ask your friend. Ask the question, he will answer. We are not supposed to answer. Immediate action in that their appeal. No, Mr. Why did you not challenge the order passed by learned single judge? Why did you not challenge? Where? The order was passed in the year 2011. Why did you not file an appeal? They are not ordinary people. That's why Mr. Prashant Chandra represents them. He doesn't represent ordinary people. That's it. Anything else? Why? Thank you. Okay. Nothing is left. Thank you. Send it. Yes, yes, madam. Oh.
The table number one, table one in the synopsis is the claim which was made before the land tribunal. Three claimants had claimed certain land claims. One is Chadna Basava Devi, Agappa Sarva Shivana, and Subbalingaya. They had claimed certain land claims. Thereafter, the order of the land tribunal, wherein only certain extent of land was granted to these claimants. Not the entire claim made by them was allowed. Only certain extent was granted. And thereafter, one of the persons who claim was rejected had challenged it in an appeal number 30 of 1987. But at the same time, the Archak of the temple had also filed an appeal. Appeal number 135 of 1987, which is at table number 4. Archak had also filed Archak had also challenged the tribunal order. Thereafter, this order of the land tribunal was set aside in these appeals. Against which the claimants came before this honorable court in LRRP 2763 of 1989, 71 of 1989. They disposed of, setting aside the entire order of the land tribunal. All the land, the initial order of the land tribunal was set aside and the matter was remanded to the deputy commissioner. Thereafter, after perusing of all the applications, came to the conclusion that the Archak would not have tenanted these lands because they are inarmed lands. It could not have been tenanted. On that ground, the deputy commissioner rejected the claim of these claimants, against which they came up in a writ petition. The learned single judge at the point of time, the land tribunal had granted certain extent of land. It is not right to have dismissed the claim, and hence has awarded the claim of these occupants. The submission before this honorable court is the earlier order of the land tribunal has been set aside to the LRRP before this honorable court. At the first instance, it is being adjudicated to the first time before the question. And secondly, the lands in question are inarmed lands. The Archak of the temple had no rights to leave these lands. The Archak was made a party before the land tribunal and also before the appeal and also before the High Court at the earlier point. And also before the deputy commissioner, the Archak of the temple was heard. First time before the learned single judge, the Archak was the beneficiary of this inarmed land, was not made a party. That is very important. The last step, it was a question was posed to me, that why the temple has not challenged this order. But my lord, the temple authorities, the Archak of the temple is not at all made a party before the learned single judge. Hence, it is bad for non-joint of parties. He is the beneficiary of this order, of the deputy commissioner and also of the land tribunal. But in the rate petition, order of the competent authority, which is a translated copy at page number 41. The respondent number 1, Shivappa, son of Nanjappa, is the Archak of the temple. He is the beneficiary of this order, which was challenged before the learned single judgment. He is not made a party in the risk petition. Without hearing him, the claim has been granted in favor of the respondents hearing. So the main submission of the state is that the petition is bad for non-joiner of parties, because he is a necessary party in the petition. The learned deputy commissioner comes to a conclusion that the respondent, the Archak of the temple, and after his death, Shivappa, being his legal heir, was considered as an Archak. They took the lands under Gupta from him, which is the respondent's hearing, from 1963 and have been in possession and enjoyment of the same. On this ground, they claim registration of their occupancy rights. The lands in possession of Subbalingaya, father of respondents 1, 2, 3, 4, and 5, was in 1963. The lands belong to Rameshwara temple, but they have failed to make any attempt to establish that the Archak had right to alienate or lease the Gupta lands. The rights are and restricted to worship and other religious activities of the temple. He had no right to alienate the inarmed lands of the temple in any manner, that is by sale, mortgage, or Gupta. If occupancy rights of the tenant have to be confirmed, the person should be in lawful possession under regular tenancy rights and also in continuous possession of the lands in question. As the provisions of the Act, petitioners 1 to 5 failed to establish that they are lawful tenants and are in possession and enjoyment of the land in respect of which they are sought for registration of occupancy. Hence, the claims were rejected, rightly rejected. Not the learning single judgment. Para 6, page number 22 of the writ opinion.
Yes.
There is also no merit in the content of the learned High Court government stated that abstract of the temple had no right to lease the land in favor of the petitioners. In those days, temples were managed by architects who were under the administrative control of the Taluk Musarai officers. But the relevant point to be considered is whether the petitioners were cultivating the land as tenant on 1374. If that is satisfied, there is absolutely no reason for rejecting their claim. In fact, land tribunal on an earlier occasion had granted occupancy rights of the land in petitions. Since the tribunal by the very same order rejected the applications of the others who challenged it in appeal and later in LRRP, this observation is wrong. The appeal was challenged with respect to the claim made to all these respondents.
Word change.
One is the Archak of the temple had challenged the appeal in 135 of 1987.
State had not challenged.
Well, the Archak had challenged the order of the land tribunal granting occupancy rights. And one appeal was challenged by Madhava, whose claim was rejected. He had also challenged the order of the land tribunal. At that point of time, both these appeals were allowed. And occupancy rights granted in favor of these respondents were set aside. Those orders were challenged before the learned, before this honorable court in LRRP. And LRRP set aside the entire order of the land tribunal. But the observation of this learned single judge is that since the tribunal by the very same order rejected the applications who challenged it in appeal and later in LRRP, and this court by common order allowed all those LRRPs and set aside the entire order of land tribunal and remitted the matter to the second respondent. Since by then it was held by this court, the tenancy pertaining to Devgaya Inam land is to be considered by the Deputy Commissioner of concerned district. Further, there is also no need to remand the matter to the Deputy Commissioner to reconsider the claim. I am satisfied with the claim of the petitioners that they were cultivating the land on 1374. It is enough if a direction is issued to the Deputy Commissioner. Whereas the matter in LRRP was remanded to consider their claims afresh.
This is the LRRP order.
Please. Archak was also made a palpable. Fine. All the petitions are allowed, setting aside the improved order passed by the appellate authority in appeal number 135 of 1987, that is filed by the Archak committee, as well as the order passed by the land tribunal in case number so and so dated 27/8/1987, and all these cases are remanded to the competent authority, that is a special deputy commissioner, for fresh disposal in accordance with law by giving opportunity to all the contesting parties to adduce their evidence in support of their respective claims. Registering directive. Thereafter, competent authority passes an order considering the claim. It is produced at annexure A of the writ petition at page number 41 of my writ opinion. Checks the claim of the respondent.
Has the temple participated in the proceedings before the tribunal? Has the temple participated in the proceedings before the tribunal?
Yes, sir. Tribunal, the first instance, 1987.
Participated.
Yeah, they have also filed an application.
Temple,
Temple, the architect of the temple.
not Archak. Temple is the appellant here. Third appellant. Ah.
They were made parties only in the writ petition for the first time.
It's annexure A.
Next year is the order of the deputy commissioner. Wherein my lord, respondent number 1 is the archak of the temple.
Who is respondent number 7?
Rameshwara Devi.
Is there?
Yes.
Why do you say it's not there? Did not participate there. Never contended that Archak had no authority to lease it. For first time you are saying it now. Why did you not say it before the authority?
Before the deputy commissioner also is passed a legal observation. Not me kindly turn to page number 48. Page number 48. Second paragraph.
Yes.
Very good. The lands and possession of Subbulinga father of petitions 1 to 3, 4 and 5 under Gupta agreement in 1963. The land belongs to Rameshwara temple. But
The finding of the deputy commissioner.
Please.
That is the finding of the deputy
Yes.
commissioner. You never participated.
Archak also has to be held in the writ petition. He is a
Right.
party before the deputy commissioner.
He was a party as a applicant.
Yes, sir. With the rival claimant.
Rival claimant.
A rival claimant.
Rival claimant. He has not bothered to challenge his rejection. His claim is rejected. He has not challenged it.
His claim is not rejected, my lord. The claim of the respondent claim was rejected by the deputy commissioner.
What
His
has-
appeal was allowed, my lord.
What has happened to his claim? What is the name of the Archak?
Shivapam.
He is the first respondent.
First is.
You read page 49, order of, it's rejected. Yes, he has not bothered to question why he should be made as a part. How the single judge could have directed the deputy commissioner to issue a order in your favor? Demand your. Yes, but how a direction can be issued? Whatever it is. You know the position of law that such a direction cannot be issued. Can such a direction be issued? It's correct. That is for the deputy commissioner to consider, but such a positive direction could not have been issued. Directing the deputy commissioner, nothing survives if such a direction is issued. Remand the matter and direct the deputy commissioner grant the occupancy right means what survives there? Why remand? The deputy commissioner consider it afresh. That extent it may have to be modified.
Then that I
It will be remanded.
listen.
Remanded, only that operative portion will be modified.
No urgency, right? 130. The witness box system. It will be. Hey, Mr. Therefore, have you got the witness box? You didn't tell them. You didn't tell them that case has been adjourned. Morning, I told them. They got it at the after. After the case is adjourned. What's the use? Yes, Mr. Huh? Password. Yes. Huh? No, madam, all this is 10 years now. How many? No. This appeal is pending for past 10 years and you are planning for next 5 years, right? By filing documents. No, this 19/10/2022, you appeared. Your name is Srimati Nimisha Kumar. See the file order sheet. 19/10, you appeared short time. What is this matter about? What is this matter? That doesn't mean that is constitutional validity means senior counsel. You make some alternative arrangement. Not- How many? No, 10 years. I mean, and you don't expect us to adjourn. 10 years. Don't have any option but to proceed. You don't have any option. In a 10-year-old case, you cannot seek adjournment after adjournment. 19/10/2022, we have granted you adjournment. Then, no. Seek 4/10/21, advocate for appellant seek 4 weeks time to file payment details before Provident Fund Commissioner. It's all adjournment tactic. At the request of learned counsel for the appellant, call on 6/9. 2nd September 21, you sought adjournment. Then 12/8/21, again your name Srimati Nimisha Kumar, praise for adjournment list after 1 week. We are parties. I am a party to that. See the order sheets, madam. I mean, we must appreciate, your capacity to seek repeated adjournments. We don't. This all, filing an appeal thereafter memo after 10 years and seeking adjournment. This not true. We will not. No, madam, this is very unfortunate and unfair. We have told you the order sheets. Repeatedly, you are before us. I was sitting in a different combination. No, matter was argued. That doesn't mean that it entitles you to seek as many adjournment as. So we will list it after 5 years, madam. So we will direct that it will be taken up when you are designated as senior counsel. We are not concerned. What this is, the fact remains. It's a 10-year-old appeal. Why did you not file? It's your outlook. We are supposed to. We have not called for any documents. Court only requires you to argue. After 10 years, you are seeking adjournment. No. Madam, thrice you have sought an adjournment before us. We have pointed out from the order sheet. Disgusting. No, that doesn't mean constitutional challenge. That means It has not to be argued. Who told you? No, no, we will appoint an amicus curiae, and don't think that we cannot decide the constitutional challenge. Don't be under an impression that without you addressing this, we can't decide. Don't tell us. Twice you have told us constitutional challenge means what's the big deal? Do you think that this court has not delivered judgment dealing with the provisions? Nothing, madam. You are trying to tell us that as if it is beyond us, we can't decide. No, what twice you have told what constitutional challenge? You should be ashamed of yourself, repeatedly seeking adjournments in a 10-year-old matter. We, from the order sheet, we are pointing out that even before this bench, you have appeared and you have sought adjournment, and you don't feel anything like constitutional challenge. We will tell you what is the constitutional challenge right away. Give it. Nothing to it. Constitutional challenge. We will decide what is the constitutional challenge. Start preparing SLP drafting if you are so advised. Nothing. There is a limit to everything, man. Limit to being nice also. You take things for granted. You come with an impression that whatever you do, you will get away with it. It's not that. We want to break that impression that adjournment is neither your fundamental right nor birthright. Nowhere Constitution guarantees that when the matter is listed, you will have a fundamental right to seek adjournment. Let Supreme Court say that we should not have granted, we should have granted adjournment, but we'll decide constitutional challenge. Nothing. Was provided for that. Correct. Nothing. Yes, anything else? But we don't, we don't know. We were not there. We do not. No, we are asking you a relevant question. On what grounds validity of a subordinate legislation can be assailed in a court of law? Tell us. You are challenging this condition number 25 of Appendix A to para 27A of the Act. What ground can you challenge the validity of a subordinate legislation? First, tell us, because you have raised an issue of constitutional validity. That's not the point argued. It is you, the case was before learned single judge was that it's violative of Article 14 and ultra vires Section 72 of the Act. Excessive delegation. All right. Nothing. Forget about it. No. Forget about it. We have told you. We only asked you so that we can write in the order sheet that we have heard you. That's why we asked you. Go ahead, forget about it. No. This constitutional issue needs to be settled today itself. And no, we want to, madam, we want to give this impression which the members of the bar have that adjournment is their birthright. Which law says that three adjournments you have sought and CPC also beyond 3 adjournment not permissible. Forget about it. This is 2012 matter. If you want to say something, otherwise we will judge it. Serious consequences, that doesn't mean that you will keep it pending for 15 years. Nothing. May not be there. Whatever. We are not concerned what transpired between you and Mr. Holla. We are concerned with the fact that this is 2012 petition appeal and we will decide it today. Nothing. No. You did not argue rudely before. We are not granting any adjournment. If you want to say something, please feel free. So this is excessive delegation and violative of Section 17. We don't know what you have to argue the case today. What happened in previous bench, none of us were there. And we did not see you. Obviously, you will agree. No, were we present? There? Nothing. No YMT. You have raised the constitutional issue, constitutionality of a provision. You told us thrice, right? Constitutional provision. We are deciding constitutionality of a provision. Let it remain pending. It is pending before us. This appeal, and it has to be decided today. That's it. That's it. You will get the judgment. Appeal dismissed today.
Yeah. Number 52, the authorized
Which case? 51? 52. Madam, we are not in any informal conversation, right? It has been, we have told you the result also. And you will see the judgment in the evening. By 5 o'clock, it will be uploaded, or 5. Before today, before leaving, we will sign it. That's it. Start drafting SLP now. Yes. This will result in, madam, this will result in imposition of costs, your conduct and everything, what you are doing. Despite another case being called, apart from this thing, another action is called for, amounts to interfering in the. Yes. No adjournment. No. That's why you were smart, right? At 132. This is the order sheet. No. See the order sheet. We are bound by our orders, not like this. No, read it first. No, read it. Not fair on your part. That's why at 132 we don't entertain. Read it aloud first, mister. Have the guts. So, what was your duty when that, though your lordship has said that no further adjournment, still I am making a prayer. Should you have not said this order sheet, that the order sheet records no further adjournment means no further adjournment. Forget about it. The standards cannot be different for that lady and for you. It has to be the same. Nothing. No, nothing. No respectful submission, argument. No adjournment, otherwise we will dismiss. We will dismiss this appeal, whosoever, if you are not interested. What land acquisition proceedings are quashed? Yes, mister. Go ahead. Will not be adjourned, right? You be clear. In a pass-over round, that doesn't mean that the council will go anywhere. Which court should be given preference? Tell us. This is a division bench. He is arguing before single bench. Which bench should be given? Court should be given preference. And this is a 2012-13 matter. Why should you not argue? When we have said that no adjournment shall be granted. It will be taken up today, Mr. Don't be under the impression that we will leave you. We will permit you to go scot-free. Sir has a sanctity. We are bound by it, even though you may try to mislead us, but this not. That's why you have understood this. Now don't make any prayer for adjournment in this court out of turn. In all fairness, at 132, you should have told us that this is an order sheet saying that no adjournment, despite that I am seeking an adjournment. Nothing submitting. Don't be over smart, Mr. Don't. No, this is what is recorded. You have not just now read it. No, supposing if we would have relied on you, we would have violated our own order by granting adjournment. How convenient it was for you. Don't, Mr. Otherwise, now henceforth, a cost of 1 lakh out of, and we have noted you down. Now, mentally, if you make any prayer for adjournment out of turn, at least in this court, in a bench headed by me, cost of 1 lakh. Don't appear for adjournment in this case and in any case, and that too out of turn. Don't do it. We are putting a warning. Just, and Mr. Call your senior wherever he is. Call him. This won't be adjourned. Call him, and as soon as he comes, we will immediately take up. Call him wherever he is. Come here. Where is your wife? Oh, I mean, respondent. What is it? That's fine. Where is your counsel?
No, I have appointed a counsel, but not appeared for so many years. I was not knowing the very good case at all. And later, after this COVID period, and now started meeting, not finding the officer coming. So I filed an application to appear at court. So the defense committee asked for inquiry, and they have qualified it to appear at the court. We have 2 minutes to qualify the court. And then people to submit the document.
It's for spontaneous. Allowed. Abstain. See, it's allowed. Praising you. He was praising in telling us about you, that how efficiently you have been handling this case. Better you retire. He is ready with the case. No. So are we the executing court? You want us to recover the fee and hand it over to you, is it? That he yes, court.
Permission granted by the committee, they're permitting you. Where is it?
They called me and qualified.
Permission is not granted, right? You cannot argue until as that committee grants permission. We will send for the report of the committee. We'll take up the matter day after tomorrow, right? You come day after. Fine. So and so has appeared in person. Thereafter, party in person started addressing this court. So and so counsel appeared and sought leave of the court to withdraw. Wakalatnama, he is permitted to so and so, permitted to withdraw, permitted to retire from the case. Full stop. The party in person committee is shall submit a report, shall submit an order permitting the appellant to address this court on or before next date of hearing, permitting the party in person to appear before this court or otherwise on or before next date of hearing, just on 17 Thursday, 17 November.
I booked a pitch for the appellant to lordship. I filed the statement of assets, affidavit, and other statements at the counter on 14/11.
We are not here. Somewhere you have to fight. We don't know which where.
You served a copy on the other side.
Yes, we have served. I have served.
No, have you received a copy from the other side?
Yes, I have received the copy also.
When have you filed this assets and liabilities statement?
On 14/11.
10 is today.
14/11. 14/11.
14 is today.
Sorry, 10/11. Sorry.
You file. So Mr. What happened? Why what has been done? He is appearing for the husband. So petition dismissed. His petition has been dismissed. So, yes. Correct. So Mr. What is it according to you have gone through statement of assets? We get it in from the statement. Do we get it that he's earning 1 lakh? Where is statement 10/11? Ringgit. What 60,000? How much is the land? Agricultural land? Agriculture, what is the extent of?
Where is the land? Liability what he has filed also is not before the court.
You file it, learned counsel for respondent undertakes to file file a statement pertaining to assets and liabilities during the course of the day. During the course of the day, office is directed to place on record the copy of statement of whatever copy of the affidavit filed on behalf of the applicant on 10/11/2014. List on day after this what? 16th November.
55, the judge Joseph.
Adjournment. Forget about. You have heard, no, you have heard us telling several times. I think 7 years. 7 years is long enough. Your petition for cruelty and desertion has been dismissed. When the marriage took place. So what happened when your wife left the matrimonial home? But isn't
This is your second marriage.
matrimonial home? Cannot say that. Desertion. That's all. Nothing, forget about. No request. 3 para 21. What else? There has to be a pleading, right? Specific instances with regard to cruelty have to be pleaded. That's the law. You understand? Very good. We have to decide the case in accordance with law, not according to what you understand. How is it? This finding is incorrect. What is it? Where is it? Para 5. Read it. What are you reading? Oh, what did you think we asked you? Petition. See tomorrow. Tomorrow never comes. No adjournment today. You have seen it. You have not challenged any constitutional validity of any provision. 7 years, how long? 22 is also coming to an end. You want to keep it pending for 5 more years. And then tell the client that High Court is not hearing. What can I do? What do you tell your clients? Just now, you heard the party in person appeared and how he praised his counsel. You heard that. How do you manage? Court is here. I mean, after you not granting an adjournment, you are behaving as if nothing turns upon this. How do you manage? That an appeal is pending for 7 years and you are seeking adjournment. What will you tell your client? Should we not call him or her, him, and see your performance here? And this is what your advocate is doing. Why have you not read it? The whole day was at your disposal. The case has been called at after 3 p.m. What did you do, even if you had not prepared? Why you should not have taken record from the court officer and should have gone through it? Nothing. There is no issue. The issue is that you have not pleaded the specific instances of cruelty. And second issue is that you yourself have left the matrimonial home, therefore you cannot take advantage. Can it be, law can be like this, that party gets married, right? Some 2 persons get married. One of them leaves the matrimonial home and after 2 years files the petition seeking that dissolution of marriage. Can the court grant a decree according to you? Nothing. No, nothing. No one day. Fine. Hey, don't bother about anything. Why should you get the record? Why? Don't get the record. Nothing. No tomorrow. No tomorrow. Okay. Thank you. Don't take the trouble of getting the. It will tell the client to prepare, go to Delhi. You should also dismissed, appeal dismissed. Nothing. No password. If you have not done anything till 3:30, what will you do? Password. Thinking, just hoping that it won't reach, right? That's what it is. Hoping that seek a password, it won't reach, so then get away. Let's do tomorrow, someone else will come. No, nothing. Huh? Nothing. Forget about it. Repeating the same thing 10 times doesn't make a difference. Okay? Forget about it. Tell the Supreme Court what mentioned exact words, right? Appeal is dismissed. Tell Supreme Court what did you exactly mention. Get it at that time. Start drafting. Give this thing everything for translation. Thank you. Dismissed. Judge has to be consistent. We decided not to adjourn the case. And we have but tell him.
You want to argue? Passover, you want to argue? Yes.
No, but the judgment will be passed today only. Don't be under the impression that it will be adjourned. And going away from this court won't help. Like, I mean, so that if you don't come back, so we will adjourn it, nothing like that. The judgment will be delivered today itself, and we have told you the result also. If you want to tell us anything, argue something, do it today itself. Today is the last day of your appeal in the High Court. The best thing is not to bother about it. What we would suggest is, because court is doing it on its own. Court is reading your file, court is recording, reason deciding it. Why bother? Tell him, take him to Delhi. No question of pass over, Mr. The judgment. If you want to address anything, you tell us today itself. But if we get up without hearing you, that means it's gone. We have already, judgment will be delivered today only. But my lord is more considerate. He's giving you an opportunity to say something, whatever you want. Don't be under an impression. That's what we want to tell you, that if I go away and don't come back, it will automatically be adjourned. Nothing like that. The judgment will be delivered today itself, whether you come back or you don't come back, whether you address us or not address us. Got it? Only dictation has been deferred for the time being. Today is a bad day for them. They'll really put me on. Girl, the way she was. Yes, Mr.
Yes, ma'am. I'm for the appellant in this case, ma'am. Serial number 56.
Password.
The respondent counsel is not there. It will be passed over, sir.
Repeatedly.
Three methods. You are all not there.
What happened? Dismissed.
Serial number 56. I am for the appellant in this case.
That is passed over.
Great.
Password, Mr. Please wait. Yes, next. Yes. Password.
Okay. Password 67. Okay,
Wait. It's covered by a judgment of Supreme Court. What is slightly different? That name of the appellant is different. Name of the appellant is not new tech. So why should you seek a week's time? 2020. Why it has been listed for final hearing? To enable you to seek adjournment, right? That same thing, right? 100%. So that we are holding in your favor, right? Can't 43,543, it cannot direct 100% of the amount should be deposited. Oh, responding. Yes, I'm running you. Out of breath. No, relax. Don't worry. No order will be passed until you are heard. Yes, Mr.
What?
He's praying for adjournment. That's what we were telling him. He says that his name is not new tech, so therefore it won't apply. It's only new tech, right? Judgment applies to new tech. His name is what? Shri Vision Towers Private Limited. So it won't apply. Why? Covered? No. What to do? Incorrigible people, we can't make them argue. In 2012 appeal, we have to close the judgment, but they haven't argued. So this only 22. He's taken by surprise how it is listed, right? The rate counsel for the appellant waits for adjournment. Where the case and argue the same list after 2 weeks. What did ask him? He will seek another adjournment. Now, what can we do? We are ready to hear today also. We can decide it. We are telling him that it's covered in his favor, not agreeing what to do. No. It should be. It's being unfair, right? We are hearing the writ appeals of 2012. So 9 more years he is entitled to seek an adjournment for 9 years at least. And 2032, some other judge, honorable judge, will decide it, right? No? What to do? We are ready to hear. After 2 weeks, it will come up. Or file an application. Yes. Ready, Mr. Latif?
Government educate.
We want to take up. You just mention when he comes. We'll take it up. We will hear it today. Don't worry. We'll hear it. Next.
69.
Pass away. All right. Next. You can mention Mr. Latif whenever he comes. Yes, Mr. No, it's all right. What happened to your case 2012?
There's a batch of litigation pending insofar as that definitive rate case where the learning is that the very learning is in the past of school order. In that judgment, part of the entire having lapsed. Declines of that. This complete shortfall is the very same legal declaration that they also on the alleged ground that we have some, while all our answers, some are no doubt.
What happened to writ appeals?
Well, they're pending. In fact, the batch is pending. In the WA number 4583 of 2011 onwards.
583. It should be heard together. It should be heard together.
They've been in the rate case.
Right? One minute. Should it be heard along with that bunch?
Something different from the sound of the truth in otherwise case of value. A person is interacting not. Subsequent purchaser cannot challenge the legality of the acquisition. But they can certainly seek a declaration that the acquisition is lapsed. My prayer and the repetition, unlike what the learner has submitted, is that page 117 specifically for declaration that the acquisition has lapsed. Kindly see page 117.
But in other cases, it has been held that it has lapsed.
In the other case, it is held as lapsed. Other cases.
Then it should be. It's the same issue. It should not. Should it not be heard with that appeal? 2011. That's what WA 4583 of 2011. Should it not be heard if in that judgment, as he says, it has been already a finding has been recorded that the scheme has lapsed.
According to fact.
Whatever. But this very issue, the finding is there in other cases, right? It has, that's what we are saying at this point of time. It should be heard along with that, whatever, so that whenever you say.
I thought it disconnected because I had to.
Hey, mister, that you shouldn't do.
No.
So what notice has been issued? We'll issue notice of this. No, but the issues, but the issue is common, right? So we can link it along with 4583. No, we will record, I mean, all of you submission. We will say that they pray that if it's pending, right, same.
It is not merely that, there is a bat of about 25 years.
No, what happened? Please understand, I mean, the question of propriety, Mr. Supposing if we hear and negate, we dismiss his appeal. This thing, it's the issue is foreclosed so far as other appeals are concerned without hearing the counsels in that case. Please understand. So this, we will have to pass some order on his IA. Issue emergent notice of IA 3 of 21 to propose respondents.
Amendment.
What that we will consider, let them appear. Amendment, what do you say?
During the pendency of this repetition allotment.
It is
inquiry is now out of the details.
list immediately after proposed respondents are served. We don't know. Let it be like this. You make an application. Parties, let the parties make an application for leave. Otherwise, then this happens. Yes. Yes. 15.
They order take the report, they go to pay the petition. You are not challenged by the already you will not they should get body of that land. You also interpret the respondent hearing will not the land possession was never taken. The opponent's the same land. Was not taken.
When was it denotified? Don't look at him, he's not coming. When it was denotified.
It was denotified number one. 3/2/2010.
3-2. That was challenged in a writ petition. And it has been allowed. Why? Do you tell us? Starts. Why it has been allowed?
Session was taken and we have the petition.
Therefore, power under 48 could not have been exercised. What is the material to show that possession was taken? What material learned single judge has relied? Which paragraph?
Page 72.
Page 72. Yes.
State government with the project proposing setting up of the tourism. The request to acquire the land. Do not do. Possession of land, I think state actually didn't do. In spite of that, never single judge. There are official details provided. Standing access in the law, taking of possession of the total extent was and public fundamentally being continued the certainly capable of being effective in taking of the same data. It cannot be described as state government has not been
What is the document to show that possession has been taken? Where is it? So whether notification under section 16(2) was issued? Not that. Say. Said 48.
which is ADP.
What ground it was challenged, Mr.? No. What grounds it was challenged before learned single judge? 4-1. Where is section 4-1 of which act? No. Section 4 is alteration of industry.
This notification has been altering the because it's a total 49 acres was possibly 55 acres. This section has been what is zero percent so there are no locals to challenge the notification. It has been filed. That's the matter. Whether the petitioner can maintain the petition challenging the notification.
Where is it? Can't maintain. Report you tell us.
2015, paragraph 63 and 64.
Okay, what 2000? Which page?
Page number 27.
Which para?
Page para 63. In view of the opposite reasons accorded by us on the basis of the acquisition notification issued by the state government, the statutory provisions of the KID Act, therefore, we have to answer point number 1 and 2 and 3 in favor of the landowner, holding the company is neither a beneficiary nor an interested person of the acquired land, and it has no right to participate in award proceeding for determination of the market value. So, determine the market value and the award proposition of the acquired land of the applicant. And the disposition part of the company proceeding the dismissal of the award part by the reference court which is affirmed by the High Court, which court is not at all maintainable in law. On this ground, itself, the disposition of the filed by the company should have been rejected by the High Court instead of allowed and remanded the matter to the court for reference of the court reconsideration of the claim after affording opportunity to the company.
No, this is not. This is not the what you are saying. That your submission is that the denotification, this thing, if a land is denotified, that notification can't be challenged by a beneficiary, right?
In this case, it's a challenge to the award. But challenging the award
It's not, I mean, it doesn't directly deal with this. Which one? Supreme Court doesn't deal with this.
No interest in they're not a beneficiary.
What is it? Which paragraph?
In this, my lord, prayer is at page 20, running page 20.
Issue read.
Now, page 56, it is argued by Shri, paragraph 45, running page 56. Could not be invoked and the KDB could not have directed a lot of land to the applicant. In Peter class 2 it is held under 54-55. Page 57, paragraph 47. In view of the legal possession based proposition, there is no vested right in the land and the copying of the document would not have applied. Accordingly, answer question point number D, the answer is negative. Question point number D is not page 40. Is other page 40, internet page 29. In this also the case was challenged to the denotification. In this matter, was challenged to the denotification that your losses will get it
Page number 20 is a prayer. Page number 20, running page number 20, paragraph 4. Base Corporation Limited filed instant declaration for the following. Issue a written circular for any of the recorded as watching the Gazette notification dated 5/5/2004. That is for denotification, notification under section 4. Court says that government is a sharing body, beneficiary is a KIGB, you are an allotting at best, you have no locus to challenge, no vested right in that behalf. And apart from that, first of all, guidance by who the beneficiary, he takes this 54 acres, gives it to.
Hey, Mr. What ground this notification was challenged?
Well, say that they are the beneficiary.
That's all. That's all right. Why?
It's a IT part.
They are a beneficiary doesn't mean that notification issued under section 4(1) is per se bad in law. What ground it was challenged? Non-application. Don't read. Tell us who have read it. Tell us what ground.
54 acres has been ordered. They want to do an IT project, and this land, which is also part of the 54 acres, is ought not to have been exercised because it is they need the land to build their house. As on today, not even one single stone is left in 54 acres. Understand what is the problem in the definition. And principle of estoppel, they urge principle of estoppel one having acquired a notification to
why their petition has been allowed?
The acquisition has been upheld by the acquisition has been upheld. That's why the denotification.
Where is that?
Uh, 73. That the final notification did not indicate the petitioner as a beneficiary of the land and page number 72, last paragraph. 72, I'll read from the beginning. The question whether the petitioner has a locus to question the entry notification realizes is based on so and so. By response number 3 would not be relevant. In the instance, the stranger has also notification issued for by the state for denotification of the road. The possession will be taken in respect to not to the state to issue such a notice, both the landowners and the state. Though it is true that section 22 of the report does not indicate that petitioner as a beneficiary of the land, it is not considered to the fact that petitioner of the state government with the project before proposing to the project. With the request to acquire a land, this is not the procedure contemplated in the KD Act. So far as the acquisition of land is concerned, this court has already taken note of the practice. In this case, very petition earlier. As you also please to point out section 48, position is a bar under section 41. Under statute.
No, but that's not an acquisition under Land Acquisition Act. Under KI.
At any point of time, any point of time, section 4. By notification, any industrial area, or include thereof any additional land as per this. Okay, any point of time include or exclude an area under which has been exercised. Then, therefore, Because if it's for one company, but not that anything from there to they take the land, give it to monthly. Monthly also is not done. Now is a serious liquidation problem, want to jail, and they want to do real estate. Now they want to give it to some third party. Money land, they want to trade with third party money. And the amount given is no, this is nothing but real estate business. Common man planning.
You are a common man. Eh? You are also corporation, right?
What we did was they filed an application, we filed an application to develop a project in my own property. They said, no, you can't do anything. This is means that we are not going. Come to the conclusion that we not aiding the beneficiary. Having held that, giving saying that they likely to allow the acquisition. Absolutely no reason.
Not beneficiary means he is not connected in any manner with land acquisition.
In that project, they included my land. That the proposal was valid for 2 years. As of today, they don't have
No. So the land has not been allotted to him.
Not as of now. They know. In fact, there's a proposal given to him for 2 years. That proposal also is that single window clearance project. So allotment, lease considerably nothing is being done in favor in favor of this land. And other balance 54 acres also which has been given to him, they have not done anything in both times. These are very valuable for the they have not tried over.
Only this side. This side. Huh?
Diagram.
Yes. This side. You are saying no. We just are trying to understand the direction. You said this side. So towards airport. Yes. Yes.
Page 96, paragraph is a judgment of royal operating. Page paragraph number 26.
So your first submission is that there is no locus, right?
No locus.
No locus because he is not even in a lottery. What else? And under section 4 of the act
can be altered
anytime. No, but why the petition has been allowed?
Absolutely wrong. What the only last paragraph
That's it.
This last page 100.
Which compilation?
First compilation they gave. 17th February.
Page?
Page 114.
Yes.
Page 118. The pleading and document by the parties in this case is clearly shown on page 119, paragraph 37. The pleadings and documents filed by the parties in this case clearly show the corporation has made a false objection to the state government. The land was needed for execution of tourism related projects. In the meeting held on 13th January 1987, after 4 years of the issuance of declaration, the managing director of the corporation candidly admitted the corporation did not have the requisite finance to pay the acquisition of the land, and Diamond Pipe was also prepared to provide funds subject to condition, including transfer of real estate to different owners, land to him from the housing project. After 8 months, the corporation passed a resolution of transfer of 12 acres of land to Diamond Pipe. The corporation transferred 2 parcels of land in favor of Bangalore International Center and so on. These transactions reveal the true design of the officers of the corporation who first succeeded in persuading the state government to acquire a huge chunk of land for public purpose and then transferred it to major corporation of acquired land in private individuals and corporations and citing poor financial health of the opposition cannot be overstretched to legitimize the patent illegal fraudulent exercise of undertaking depriving landowners of the constitutional right to property with the use of private persons. It needs to emphasize that if the land is to be acquired for the company, state government of company is going to comply with so and so. Therefore, the corporation did not have the duty to transfer land acquired from the public purpose to companies and thereby allow them to bypass provisions of the deviation of the purpose. Diversification of the purpose of land which was acquired under section 4.1 of section clearly amounts to fraud on power eminent domain. This is precisely what the High Court has held in the judgment under appeal, and we do not find any valid grounds to interfere with this case. And because of so, the High Court has fought. Very soon, Diamond Pine law is a beneficiary of this land also. Same order is that KDB requires the land. He files an application for the single window to allot this land to me. And after that, what it does, it gives it to monthly. Officers are filed by monthly process. Whatever how the is being done, and when my core I asked to do on my land, there is no 54 acres, which is not made a stone. They are valued and identical and fair purpose. On the matter was going on, it is given to monthly who files the affidavit during the proceeding. I monthly spare. I am the authorized signature in monthly spare Malya Hospital. Malya Road. I submit I am the authorized signatory of the petitioner. So this company, Lakeview Tourism, when the petition was filed, was being handled by Diamond Pipe. Subsequently, when the proceedings goes by, the authorized signatory become monthly developer. In fact, that is also was pointed out in the various things. This is what they are doing in our property, our land in question. So this is apart from that, this is an abuse of property, another power. But
So you get a center. Creation facility, so on and so forth. And you can estimate the profit. Because the land, legal vehicle is what we acquired, but the government, if they produce legal vehicles, thereafter, on within 2000 months, government had to acquire 70 acres land in favor of the point number one. Second was the government, the government, not the case, KID, the objection created the KID Act. Therefore, next KID to acquire 70 acres land on behalf of all the rest of the because letter is issued by KID on 12/10/2000, directing the one one, we are supposed to be 1 crore. 40% of the total acquisition costs in order to start illegal image notification. Because we take page 121. Ask for guidance. And requested deposit is 1 crore 8,42,000 to the board to PD drawn in favor of CEO and executive member paid in Bangkok. So as to cost the notification publishing percent. For my lords, is addressed to the using operation. Prior to the issuance of the preliminary notification, the lords letter was issued lately. Lords, what the attention taken by them is an nearly awardee and not beneficiary. Those are the two hands of the acquired. That issue was for the responsible. Although the beneficiary, the was made in favor and so to the one because we are beneficiaries of the acquisition. Subsequent to the issuance of the notification, the applicant starts purchasing the land.
Where is the allotment in your favor?
There is no allotment in the and will subsequently reverse it after the notification, the applicant starts fixing the property is subject matter the lands the subject matter notification, but all acquired subsequent to the notification and 3 acres of land subsequent to the notification to the KD, the A4 KD. But subsequently, what happened? VDA also had sort of acquired single lands, subject matter of within notification. Therefore, the district had challenged. One had challenged the VDA notification for this on to court. This on to court was VDA notification saying that, and in fact, Lake itself, respondent one had challenged the notification saying that I was the beneficiary of the land. Therefore, it was if the individual VDA acquired the same property, but the cost of the respondent one. On 25/11/2002, the KID issued the final notification in favor of respondent one, acquiring around 55 acres land in Total submitted the applicant purchased the lands to unified subsequent final notification of by KID. I have put in the series indicating the purchasers gave the applicant notes as the rejoinder notes available at page 334 notes of the appeal notes. They purchased the land subsequent to the final notification 28 for the KID. indicate words.
No, Mr. What is the ground of challenge to the notification issued under section 4 of the Act? What ground? Why the learned signatures allowed your writ petition? Why? Point out.
Was what to pay. The applicant's land. It 7. Mazel of the land and portion the land had been taken. But 1 in 2004 itself. 6 years later, Lord, after the position is taken, the AIB decides to denotify the land without mentioning the reasons as to the denotification. In fact, the example says the government is not.
So no reasons were mentioned. That's all.
The land is
Promissory stop.
government words, in fact, offers the acquired or pick a regular land into the fund one.
That promise will bind the appellant.
That's what
No, you tell us, we want to know. Supposing if he makes some government advocate makes some promise to you that he will offer you coffee after you finish the argument. Whether it will bind, that promise will bind Mr. Shetty also. Well, obviously, I mean, you have understood the question, right? The appellant is not bound. How doctrine of promissory estoppel applies?
Why, for the purpose of the land be ordered in favor of the responding one.
No.
The position has been taken.
To the court. No, please tell us on what grounds the notification issued under section 4 of the Act was challenged. Firstly, you said no reasons were assigned. Secondly, what promissory estoppel? I mean, the government could not have, so like in view of the promise given to you, government could not have issued a notification under section 4, right? That's the argument. No, notification, because a promise was given to you, therefore notification under section 4 of the Act could not have been issued. That's the argument. No, but what is section 4 of the Act?
Right now, we move inside the judicial proceedings by the they only seek for reason for notification, not forthcoming from the why the area after 6 years after the filing notification. Side notify small portion, 4 acres and 10 guntas of the appellant's land not forthcoming. But since the fund one effectively which of the land has been taken, the awaiting transfer of position, the fund one, the notification have been got notice and the reasons are also coming to the notification file the government. Which have been taken. Okay.
No, it's not. Just section 4 is not worded like section 48, right? Therefore, that's not relevant whether section 4 is not worded like section 48. Which provision of the Act says that it can only be withdrawn if possession has not been taken like section 48? No, you answer you have understood the question. Which provision? No, which provision is there in the Act, like section 48, that they can withdraw only if possession has not been taken over? No. Answer is either yes or no, not submission. There's no provision like section 48 in the act. Why is it so difficult to answer the question, Mr. Straight? Answer, is there any provision like 48 of the Land Acquisition Act in KIADB Act? Not there, right? Section 4 of the act enables them to withdraw. That provision does not put any embargo on the power of the government to withdraw from acquisition, right? So therefore, what we are trying to say that notification under section 28(7) doesn't matter, not relevant. Possession taken, not taken, doesn't matter, because they can exercise power at any point of time.
The following was a legal reason.
Page
61.
Yes.
In view of this code, this number paradigm. So this code, see Thomas Arthur, and on the application, the declaration under subsection 4 of section 28 of KID Act, land vests absolutely the state government. But the object of the act cannot be achieved by mere vesting of the land to state government. The object can be achieved only if the possession of the vested land are taken to the state government and transferred to the KID for the declared purpose. The acquisition is not complete without taking possession, and compensation is not payable unless the acquisition is complete. In other words, the landowner is not entitled to compensation immediately after vesting of the land in state government. It is held that title vests the state government of application declaration, but acquisition of the land is not complete without taking possession. It was declared that the state government is empowered because the land from acquisition for taking possession by cancellation and the subsection 2 and 4 of the KID Act in excess of power under section 21 of the General Process Act. That the state government may also exclude land from the declared industry area by issuance of notification section 4 of the KID Act. By implication, therefore, the state would not withdraw from the acquisition after possession of the land had been taken. The above view have been approved and applied in subsequent decisions, including Mula Investments case and United Matters. The consistent view of this code has been it is possible for the state government to withdraw the land in the acquisition proceedings under the provisions of KID Act only if physical position has not been taken from the same vessel. There is no view expressed that the state can withdraw land. The acquisition will have been taken by virtue of the white power area. Therefore, it was canvassed on behalf of the respondents that such power is always available, and the power is such that it was not incumbent in the state to even cite reasons for doing so. This position cannot be accepted. The respondents seek more inspiration from the observation of the expert that case was addressing a situation where a land subject matter of acquisition was so overrun by unauthorized occupants that the state government felt it was too bad to make forcible disposition and sought to withdraw the acquisition proceedings. Landowners having sought to compel the state government to go ahead the same. The apex court held that absence of any reasons assigned to the government was not material. Otherwise, but in this field, decision. The way of this court in answer to a hypothetical situation, the state government would be able to notify for that. Answer would be no. Is no. The notification order. There is no difference mentioned. She not after 6 years after decision having been taken. One in or in the area. So far, that let upon my freedom rules. Was dealing in the case of compensating enhancement. It was not dealing in the case of denotification by the landowners. This in the court of Proceedings. Based on 56, it deals with the aspect of Pirapa region. There is no categorical whether the Pirapa lots in the case of compensation. The one is applied in the case of identification as well. There's no in the case of compensation, there's no requirement. But in the case of identification, it's my land. The given is being taken away. That's what I was. He would be again by the judge. Therefore, does not deal with land, not with identification land, but it deals with land compensation. Therefore, Milwaukee actually have a lower standard Milwaukee's who challenge identification. Regulate lands to 40 hours in the statement.
Not told what powerful people what he has done. Don't enough that line of fighting for only for land aggregation. There's a land process he can give it to somebody else. No vested rights in him to claim this right. The reason given by the government in section 4 is to not fight for that.
Page.
The land is not it has decided to give up the 157. Any award passed? No. Any award passed in respect of this land? Therefore, this is even a stage prior to that. And in Veerappa's case, Supreme Court has said in the award proceedings also you are not entitled to participate. This is a stage even prior to that.
Challenge. Very even as of date, that was to the matter was take those reflections on considering whether since no application is being moved, what has been passed, can does the applications have been put in exposed then matrimonial application. Since land is to be acquired in money, without providing any reasons. Not taking position words, not rights. I just have to every land is taken away from right. I want to get the lands. Land have a low standard.
There is no figuring the preliminary and the final. Beneficiary name shown is the KADB. So the KADB has decided that they don't require person to be the state government is issued section 4. He need not be heard in the matter. And this is not required. Government says this is not required, so section 4 is issued. He has no locus to question that.
Area. In the notification. The documents are to be among the
Correct. What is name is not relative parent, it is not an allotment. The person, if he was allotee, his name would have been mentioned for declaration.
KDB Act. He's mentioned the land was have two documents show that land always must be acquired illegally. The government show the KDB was and the position body or we as a
That voice for you here. Huh?
Yes. Mr. Mo. Ready? Yes. Will what profit? It's not that difficult, right? To argue a case is not that difficult. Huh? You understand, no? Very good. Oh. Should have whole day, 3:30 the case was called. Should have seen the record instead of so, remaining cases tomorrow. To this purpose. Oh yes, EBS corpus. Mr. Sorry. Mr. Latif, yes. We'll continue tomorrow. Please mention after motion hearing. Tomorrow after motion hearing cases, you please mention this. We will hear it on priority basis tomorrow as first case.
After admission.
After admission, you please mention. You are not present when the case was called. That shows the order of preference. Huh?
Yeah.
That thing you sent, that virus, constitution validity. Huh? Important, we have to decide constitution. Huh? Very important. Huh? Tomorrow. That's what we are telling you. Please mention. Whenever motion hearing cases are finished.
Serial number.
Yes.
Serial number 59, madam. Respondent.
I appear for it. Will be repeated tomorrow. Tell them everyone. Public. Which case? 58. Correct. 58. Friday.
Court officer. Court officer.
ನಾಳೆ ರಿಪೀಟ್
ರಿಪೀಟ್ ಆಗುತ್ತಾ? ಪಾಸ್ ಓವರ್ ಆಯ್ತು ಅದಕ್ಕೆ ಭಯ ಆಗಿದ್ದು.
ಇಲ್ಲ